Welcome back. You're watching HFO-TV, co-sponsored by AMF Capital, the Janik Law Firm, the Butler Exchange Group, and the construction firm J.R. Johnson.
Welcome back to HFO-TV. I'm Greg Frick, partner at HFO Investment Real Estate. It's about the end of August here, about 6 months into this corona pandemic, and we're lucky enough to have partner Ciaran Connelly of Janik here to talk about HB 4204. It's the foreclosure moratorium that was passed about 60 days ago. I want to thank you for taking the time to explain this. We've got a couple questions kind of about the nuance of that one, so let's just jump right into it.
HB 4204 is a foreclosure moratorium that is good for owners, potentially bad for lenders. It's broadly speaking the same sort of idea. There's an emergency period with a moratorium and sort of a grace period, but there's some differences. So let's walk through it if that's all right.
Yep.
So first, the emergency period under HB 4204 is different. It starts on March 8th and extends through September 30th, same end date, but it includes an express provision allowing the governor to extend that period if she does so by August 31st. So we'll know in the next couple of weeks whether she's going to do that or not. But that's the period that we're talking about.
And she could extend that and not extend the eviction moratorium. These are not necessarily connected.
That's right. And this is a broader foreclosure moratorium. It doesn't just apply to lenders, to residential multifamily owners or anything like that. It's a broader
commercial properties too.
Commercial properties, bare land, anything along those lines. That's the period is ends at the same time unless the governor extends it by the end of this month.
Gotcha. Okay.
Now, in order to invoke the benefits, there's the tenant is going to have to send a notice, or not the tenant. The borrower is going to have to send a notice to the lender, and what that notice contains depends on the nature of the property. If you've got a residential property with less than 4 units, so small property, all you have to do is send a notice to your lender that attests, that's the word they use, that your inability to make periodic payments is related to the pandemic. Okay, and it's basically good faith representation by you that that's the reason. If you're talking about 4 or more units or a commercial property, then the borrower has to do a little bit more. They've got to send financial statements or other evidence of a loss of income as a result of the pandemic. So if you got your rent roll and people just haven't been paying, that's evidence right there. There's no standard of how bad it has to be. It just has to show that there's a loss of income in one way or another. And on top of that, you have to disclose any government assistance you got through a PPP loan or otherwise.
Got it.
All you have to do is send, depending on which notice applies to you, you have to send that notice, and you have to send it only one time at any point during the emergency period. So if you haven't sent one yet, you still can, and you can do that up through the end of September. Just have to send it once, but make sure you include the required information. And once you've done that, then during that emergency period, the lender can't default you for any non-payment. They can't charge late fees, impose penalty interest, or do any of those other sorts of forfeiture remedies that lenders use to enforce their rights during that period. And most importantly, they have to defer the amounts that are unpaid during the emergency period until the end of the loan.
It'll be added on to the end of the loan without any fees or penalties in that regard.
Exactly. So if due at maturity, right? It doesn't extend the. So if you've got a 15-year mortgage, it doesn't make it a 15-year and 6-month mortgage. It makes it a 15-year mortgage, but with just a big payment due.
Bigger balance at the end.
at the end.
Got it. Okay.
But you have that whole time to do it.
I've heard that the banks are now, I read something a couple days ago that there's talk about some banks trying to come after the state and saying, I mean, are you hearing that as well?
Okay. Yeah, I believe that the banks have filed a lawsuit along the same lines, trying to challenge the constitutionality of this. This act, like 4213, it has findings at the beginning stating that this is an emergency, that it doesn't interfere with anybody's contracts, et cetera. So it's that too is going to be an uphill battle.
Gotcha. Okay.
But the banks are challenging. And
it doesn't matter where the servicer is located or where the bank's located. All has to do with where the property is located.
Well, yeah, exactly. The definition of borrower and lender are a little bit problematic in here, but they're very broad. So from a lender's point of view, there's a concern that if you're just the trustee under a trust deed, that you've got to send notices, and that if you're the beneficiary or one of 15 different beneficiaries under a trust deed, that all of you have to send notices at some point, which we'll talk about in just a moment. But it's not. It hasn't been as subject to as much refinement as the landlord eviction moratorium statute, and so it has more problems. But that's basically what it's supposed to do is help borrowers defer payments until the end of their term.
And again, the governor could, in theory, on August 30th, before August 30th first, say, hey, we're going to extend this out.
Yes.
Okay, got it. Okay.
Absolutely.
Okay.
And then separately, the act contains a prohibition on basically all foreclosure actions during the emergency period. So if whether that's a notice and sale, a legal contract, any kind of forfeiture remedy, all of those actions landlords are prohibited from taking them. All the time, and courts are prohibited from issuing orders granting those kinds of things, et cetera. As with eviction and other landlord actions, the time frame for all those things are told. And that actually is of twofold. One, it preserves that cause of action later for lenders if they want it. But from a borrower's point of view, if you got before this act came into effect on June 30, you got a notice of a trustee sale on April 15.
Right.
Then basically no time has elapsed since that notice has happened, and that notice will be treated as having been given on the first day after the emergency period expires.
Okay.
And even then, if it was only due to an amount that has to be deferred under the act, then it may not be a valid one anyway, because there may not be a default.
I'm sure the lenders are real excited about this one.
Yeah. Well, they're as you would predict, not too happy with it.
Yeah.
This, as with the eviction moratorium, there is a right of action put in here for borrowers. It's not quite as broad, where if there's a violation, you automatically get 3 months of your periodic payments or something like that. But there is an action if you are damaged by by a lender that violates any provision of this act, then you have a cause of action. You can sue them, and you can get back your attorney fees. So you get attorney fees plus any actual damages. You do have to have actual ascertainable damages to bring the suit. So it's not just something to threaten if it hasn't hurt you yet. But if it has hurt you, you have a cause of action.
So in comparing this to like the other one, we were talking about with the eviction moratorium, this is a little bit more burden of proof on the borrower on this, as opposed to, like we've talked about, there's not means testing for tenants or anything like that. Where there is a little bit of you do have to show you have had, effects of COVID and with the lenders. So
ultimately, the lenders, kind of like the October notice that we talked about for landlords that they have to send to tenants, lenders are supposed to send you a notice as by the end of this month. August 29th is the deadline for that. So they had 60 days from the adoption of this act on June 30th to send this notice that's supposed to explain all your rights. et cetera. So if you haven't already, you should probably expect to receive something along those lines by August.
And then again, you have through the month of September to make the notice to the lender should you want to.
Exactly. And you do only have to do it once. I mean, it just because, if you've made payments up till now, but you have suffered that loss of income, you can send the notice now. Even it doesn't have to be part and parcel with a non-payment, right?
Gotcha.
You can send the notice and then you're covered. Finally, and again, this is, I think, mostly to try to avoid the constitutional challenge. It does make clear in the statute that this is not forgiveness. This is just deferral. And all the amounts that you owe under whatever arrangement it is, whether it's a trust deed with a promissory note or mortgage or whatever it happens to be, you still owe those amounts. You just get a little bit of relief as to when you have to pay them.
Interesting. Okay.
So a little bright news from for borrowers.
Property owners, yeah, definitely. Yeah, like I said, hopefully they don't need to use it, but if need be, they've got basically roughly about 30 days to make that notice into the lender, and so.
So that's HB 4204.
And again, I know when they were passed, it almost sounded like they were together, but they are separate bills, separate, actions by the governor. So yes, they were kind of passed together, and you heard, eviction moratorium and foreclosure moratorium. But again, they're separate actions. There's nuances to each one. So
that's right. And one could be extended and not the other, or vice versa, or they could both be extended. But I think part of the reason that both were passed is recognizing a recognition at the legislature that squeezing landlords only is not a fair way to try to allocate some of the problems with the pandemic.
All right. Well, thank you so much for taking the time to kind of share this. This has always been it's been a very interesting time the last since we've been in this pandemic. So I think it's kind of a moving all the time and changing. And again, now we're kind of waiting to see, is the governor going to extend or not? It was great to kind of go through those dates for people that A, how you're going to deal with your existing tenants, and then B, if you do need mortgage relief, what you need to do that. So, and as you've said before, and I'm going to reiterate it again, on some of these noticing things, especially to tenants, please get advice, legal advice, or from your management company. Times have changed. This is not how, management is a much more, I would say you're much more specific things that you need to do in noticing, and if you don't do it right, the penalties are pretty severe. So please, if you've got questions, call. We're happy to, point you in the right direction. Ball, Janik, Ciaran do a great job of that stuff, and I can't, again, say it again, do not try to go at this thing alone. It's not like it was 10, 15 years ago. The climate has changed, and you really need to have somebody on your side. So, hey, thanks for explaining that on 4204. It's good to know there are some differences between that and HB 4213. So again, thank you for taking the time to spend with us. And again, as we've said before, both of us have reiterated, please, everybody, with stuff that's going on now, do get some advice. If you need help, let us know. We can point you in the right direction. Paul Janik does a great job as well. And again, be safe, and we'll talk to you again on HFO-TV. Thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.